Hi everyone, my name is Max Jiang. I'm the Senior IP Officer based at the Shanghai Consulate. I'm delighted to present on IP protection in China, a critical topic for businesses exploring opportunities or already in the market. As part of the attaché network of the UK Intellectual Property Office, the UK IPO, we are deployed here to better understand China's IP system through constructive and direct engagements with Chinese IP authorities and to support UK business as they navigate the Chinese system, drawing on the knowledge and insights we built from those engagements. It's important to note that none of our team members are IP lawyers, which means we cannot provide you legal advice. Business will still need to refer to legal experts to develop specific IP strategies or actions for specific cases or issues. But our support helps companies frame those discussions with professionals more effectively. We work closely with partners like Invest Northern Ireland to guide companies doing business in China. Our objective is to help exporter make commercial decisions about China market based on a reasonable understanding of the Chinese IP environment and IP system. We have developed a 5-step model which can form the foundation for companies seeking to build a sound IP strategy for China. No system makes you completely immune from IP risks, but early planning, taking legal advice, and discussing IP issues openly with your partners early can significantly mitigating IP risks. It's important for companies to understand the big picture and manage expectations. Interestingly, in comparison to the UK IP system, the Chinese IP system is both different and not different at the same time. There are obvious differences, a different legal tradition, a 3-tier enforcement system, which is quite unique, and the sheer scale of the system. All of these create real challenges to companies. However, there are also many similarities. Registered rights such as trademarks, patent, and designs, as well as unregistered rights like copyright and trade secrets, are examined, protected, and enforced in ways that UK companies would broadly recognize. While some systematic issues remain, at framework level, the system has become increasingly coherent, which means risks can be mitigated to a manageable level if the right steps are taken. At an operational level, I would like to highlight 2 differences that have direct practical impact. First, the territorial nature and the first register principle. The IP rights, such as trademarks and patents, are territorial, so UK registration do not automatically protect you in China. China also places strong emphasis on first to register, which is why barefaced trademark, also known as the trademark squatting, remains one of the most widespread issues we see, particularly when products gain market tractions before trademark registration. Second, evidence. When enforcing IP right, especially enforcing unregistered rights, evidence of ownership must be presented to the Chinese IP authorities. In practice, you might have to rely heavily on evidence generated outside China, where the right was originally created. You should bear in mind that extraterritorial evidence may not always be directly eligible. You will have to process them for the use in China, which means extra time and costs are required. Once expectations are set, the next step is to secure your rights. For registrable rights, registration is essential. For unregistered right, ownership evidence needs to be prepared and suitable for use in China, as I just explained. Registration itself is usually straightforward and it won't cost too much, but deciding what and when to register can be quite challenging, particularly for SMEs. Registration forms your legal foundation in the market, but where the budget or registrability is limited, early and informed analysis is essential. The 4th step is about how you engage with partners. Many of the popular business models require a strong partnership with local companies, but at the same time, IP infringement and IP dispute risks can arise when you can't manage those relationships well. Contract enforceability is a point that's sometimes overlooked by a lot of people. Business arrangements involving IP are contractual by nature. Under the Chinese framework, you are actually given a big flexibility to negotiate and agree terms like foreground IP ownership or liability split, which could be codified in your contract with your partner. Your strongest leverage is the dispute resolution mechanisms agreed in the contract. Enforcing UK commercial judgment in China remains quite difficult nowadays. Enforceability should always be considered very carefully, especially when you work with partners whose assets are primarily in China. And finally, the last step in this model, in terms of the enforcement, IP rights in China are largely treated as private rights. While there may be occasional ex officio actions, infringements rarely disappear unless right holders take proactive steps. China has multiple enforcement rules with different features and deterrence effects for you to leverage. There are, of course, challenges like the budget, which is faced by everyone in the market. So the key thing here from what we have experienced is to plan and budget for IP enforcement, just as you would for any other aspect of your business when entering a new market. And that concludes this presentation. If you are serious about doing business in China, you need to factor IP protection into your commercial planning. Understanding the Chinese IP system and assess what your risk exposure looks like once the reasonable precautions are taken. I hope you have enjoyed this presentation, and please feel free to reach out if you would like to have a more in-depth one-to-one discussion. Thank you.